Good evening, everybody. Hope everybody is well and safe. For those who don't know me, I'm Sam De Silva. I'm the chair of the Law BCS. So today's evening session is on that topic which we're probably all interested in, or probably all sort of sick and tired of, but it still goes on and on, data protection, and basically what's happening next, particularly with Brexit and Schrems and so forth. So I'm pleased to say that we've got two expert speakers, two of my colleagues, not being biased at all, but yeah, they're very proficient on data protection advice clients regularly and help the team immensely. So we got Joanna Williams, who's a senior associate here. She is very experienced in terms of data protection and privacy. She works across a variety of sectors. She has also had a sort of quite a unique sort of career. So prior to joining CMS, she was a senior in-house lawyer for the UK government, advising on data protection and privacy. She's represented UK government on various international level negotiations, including all aspects of EU. She also served as the head of office for a member of European Parliament and the EU policy advisor to the UK law societies. She's also acted as a sort of advisor to the EU Committee of the Law Society and represented the UK delegation European private law. So we're very happy and pleased to have her speaking. And join with her, we've got Catherine Keeling, who's an associate in our team. She also specialised in all aspects of data protection and technology transactions, acting for a range of clients, both on the supply side and on the customer side, and a wide variety of sectors, including healthcare, energy, and she was previously in-house counsel on secondment at a major telecoms business. So without further ado, I'm sure you haven't come to listen to me, you've come to listen to the experts, Joanna and Catherine, so I will leave it to Joanna and Catherine to take you through this fascinating topic. And obviously, if you've got any questions, feel free to put them in the chat, and Joanna and Catherine will answer them at the end, and Panajota will wrap up. Unfortunately, I've got a client call with a New Zealand client actually at 7 o'clock, so I'll be dropping off, but yeah, Panajota will be wrapping up. So yeah, enjoy the session. I'm very sure that it'll be fascinating, illuminating. So Joanna, Catherine, thank you, and over to you.
Great, thanks very much, Sam, and hello everyone. I'm Joanna Williams, and I'm a senior associate, as Sam has explained, in the CMS data protection team, and I'll be presenting you to you tonight with my colleague Catherine Keeling. We both have a background of regularly advising on data protection compliance in a transactional context, and that includes in respect of IT outsourcing. So I'm just going to move to the next slide. Bear with me a second. There we go. Okay, so just to kind of run through a little bit what we're going to cover this evening. Many of you will know that from the 11 p.m. on the 31st of December 2020, the UK moved to a new data protection regime. However, that isn't the end of the story. And this evening, we're going to discuss some of the key developments and also risks for IT practitioners to be aware of, and advise you on how you can try to manage those risks going forward. In fact, we now are in one of the most uncertain times ever for data protection law in both the UK and the EU, with a new data protection regime applying in the UK, which is separate though very similar to the EU data protection regime, now known principally as the UK Gdpr, a temporary grace period or bridge for transfers of personal data from the EU to the UK, the possibility of two adequacy decisions not yet adopted by the European Commission in respect of EU to UK data transfers, a further transition period following on from the EU Withdrawal Agreement, this time in UK domestic law and relating to international transfers from the UK, the application of a separation period in the EU Withdrawal Agreement to deal with so-called legacy data, the European Commission's pending update to the EU standard contractual clauses and what this may then mean for transfers from the UK in future, and the possibility, perhaps, of a new EU-US privacy shield or other developments in EU-US data transfers following the Court of Justice's decision in Schrems II. And all of these developments are running concurrently. So what do you as IT practitioners really need to know? Well, Catherine and I are going to talk you through the key elements. There are also other developments that may be relevant too. So for example, the progress in the negotiation of the new EU e-privacy regulation. This talk will focus primarily on data protection, but we're happy to pick up linked themes at the end. We'd also be happy to take your questions. Please put these in the chat and we will then answer them at the end of the session. So without further ado, I'm now going to hand over to Kat, who's going to talk to us about the new the new UK GDPR. Thanks very much, Kat.
Thanks, Joanna. So some of you will already know that the UK has now moved to a formally separate data protection regime, and this results from the retention of the European Data Protection Regulation, or GDPR, in UK law at the end of the Brexit transition period, as provided for by the EU Withdrawal Act 2018, and subject to further adaptations made to it in UK secondary legislation to ensure that it functions properly in UK law. So, for example, references to the European Commission have been changed to UK ministers or the Information Commissioner's Office, otherwise known as the ICO or the UK Data Protection Authority. So as Joanna mentioned, this is now known as the UK GDPR, and it sits alongside the UK Data Protection Act 2018, which has also been amended and sets out some further details of how the UK GDPR's application will work, including, for example, providing for transitional periods for international transfers of personal data, which we'll come on to discuss in a bit more detail later on. So moving on to the practical implications of these concurrent regimes, the EU GDPR and the UK GDPR now function as parallel data protection regimes. So how do you determine which rules you're going to be governed by? As IT practitioners, you will know that businesses need to understand the data processing that they undertake. And this should be possible either through a data mapping exercise or through producing records of processing if this is a requirement for the business and if these are available. This will help to determine which regime or regimes will now apply to that processing. For example, it is possible that both the UK GDPR and the EU GDPR will apply, as both regimes have extraterritorial application, or that one or the other will apply depending on the processing activities in question. So to take an example of this, if a business is processing personal data in the context of an establishment in the UK and in the EEA, or offering goods and services to, or monitoring the behaviour of individuals within both of those territories, then both regimes will apply to that business. I'll hand it back over to Joanna now, who will discuss some further implications of this.
Great, thanks very much, Kat. So the key point to emphasise is that while the EU GDPR and the UK GDPR are extremely similar, they are now entirely separate. And that means that some additional obligations may arise for you as IT practitioners. If both the EU GDPR and the UK GDPR now apply, then this means, amongst other things, that your business should update its privacy notices to reflect this. So, for example, in the context of international transfers, with transfers from the UK and the EEA dealt with separately in the drafting, and consider if it needs to appoint an EEA or UK representative if the processing falls within scope of the relevant regime and your business is not established in that territory. If you're established in the EEA, your business should also consider whether or not it may be able to identify a new EEA lead supervisory authority for cross-border processing if the Information Commissioner's Office previously fulfilled that role for you in terms of that processing. This is generally referred to as the one-stop shop in the EU GDPR, and it still applies in the context of EEA processing, but of course the UK GDPR and processing pursuant to that is now separate. So just to kind of step back a little bit, why is this so important? Well, it's important in terms of compliance, because where both regimes apply, ensuring compliance is particularly key, given the risk of dual enforcement action by, on the one hand, the UK Information Commissioner's Office under the UK GDPR, and on the other hand, EEA data protection supervisory authorities under the EU GDPR for non-compliance, given that both regimes may apply to the same processing. Even if only the UK GDPR now applies to your business, though, some changes, minor, but some changes nevertheless are still required. So, for example, in how international transfers are described in your privacy notices. In addition, it's worth bearing in mind that the EU GDPR will still apply to any organisation in the EEA which transfers personal data to UK-based businesses. So you may need to work with these parties to ensure that these transfers continue to be carried out lawfully in the event that the so-called grace period or bridge provided for in the EU-UK Trade and Cooperation Agreement ends without an adequacy decision in favour of the UK, though we certainly hope this will not be the case. We're going to run through this further in a minute. It is also important to note that other compliance requirements, in fact, the other compliance requirements that we've just explained should be considered regardless of the bridge for EEA to UK transfers. They apply nevertheless. And it's important to ensure compliance throughout your processing activities in respect of those. Finally, it's also worth bearing in mind that in respect of general contractual drafting, there are various changes that you may wish to make. So for example, if you and your company rely on standard form drafting precedents, you may need to now make some changes, for example, to the definition of data protection laws and other content referring specifically to data protection legislation. Right, I'm now going to hand back to Kat. Thank you very much, Kat, to discuss the grace period and the bridge for EEA to UK data flows.
Thanks, Joanna. So as I'm sure you're already aware, the GDPR provides certain criteria, one of which must be met in order for international transfers of personal data to go ahead. The easiest route for this is if the third country that you wish to transfer personal data to has been found to have an adequate level of data protection pursuant to a European Commission adequacy decision. This means that no further compliance steps are required for undertaking this transfer, besides compliance with the general GDPR data processing requirements. Other routes are also available, including putting in place appropriate safeguards such as standard contractual clauses, together with any supplementary measures that might be required, or to rely on a derogation under the GDPR. For transfers from the EEA to the UK has now determined that the EEA states offer an adequate level of data protection, and this allows data transfers from the UK to the EEA to continue after the Brexit transition period is over. Again, just provided that other standard GDPR processing requirements are met in relation to those transfers. By contrast, whilst it had been hoped that an EU adequacy decision would be in place by the end of the Brexit transition period, there is no current adequacy finding in place for those transfers from the EEA to the UK. The biggest data protection headline in the EU-UK trade deal was therefore the incorporation in the EU-UK Trade and Cooperation Agreement of the temporary grace period or bridge for such transfers. This provides that for the period that the bridge applies, transfers of personal data from the EEA to the UK will not be treated as transfers to a third country as a matter of EU law. So in practice, such transfers are therefore not currently subject to the same requirements under the EU GDPR as transfers of personal data outside of the EEA to other third countries which have been deemed adequate. where, for example, as IT practitioners, you're likely to see standard contractual clauses regularly in use. In the trade agreement, this bridge is subject to the condition that the UK will not change its current arrangements in relation to international transfers without the EU's agreement while this bridge period remains. So, while the bridge is not the same as an adequacy decision, which is subject to a separate procedure under the EU Gdpr, on which we'll talk about in a little bit more detail later on, it has offered temporary respite to many businesses which do not have the opportunity to put in place standard contractual clauses or other adequate safeguards in relation to transfers from the EEA to the UK prior to the cliff edge at the end of the Brexit transition period. Without the bridge, some transfers from the EEA to the UK may have had to have been halted completely, potentially causing significant disruption to businesses. So this bridge is in place until at least the end of April, and under the treaty, this can be extended until the 30th of June 2021, if neither the UK nor the EU object, and also assuming that an adequacy finding hasn't been found by this date. Now, we hope that an adequacy decision will be in place by this time, but if an adequacy decision is not in place, businesses will need to ensure that they have satisfied another EU GDPR criteria in order to undertake EEA to UK data transfers. So at this stage, businesses still unfortunately do not have certainty as to whether they will need to provide standard contractual clauses or another form of appropriate safeguards, or appropriate rely on a derogation under the GDPR to undertake international transfers from the EEA to the UK in the future. And therefore, businesses will need to be prepared for the end of the bridge period. However, there has been some encouraging signs, which I'll pass back over to Joanna, who will talk about them now.
Brilliant. Thank you very much, Kat. So I'm just going to move on to the next slide. So bear with me. Great. So just to kind of talk about those encouraging signs, what we of course mean, and I'm sure that many of you have already become aware of this, is that the European Commission on Friday, the 19th of February, announced that it had formally launched the procedure to adopt 2 adequacy decisions for transfers of personal data from the EU to the UK. Now, while the decisions are in draft form and have not yet been adopted, it marks significant progress and the possibility of the adequacy procedures being concluded in the coming months. So fingers crossed. The European Commission has issued the draft adequacy decisions for these transfers of personal data to the UK in respect of, firstly, the EU General Data Protection Regulation, which applies to the processing of most businesses, and also the Law Enforcement Directive, covering the processing of personal data in the field of law enforcement cooperation. Now, after setting out its detailed consideration in each case, and the requirements in terms of that consideration are set out in Article 45 of the GDPR, the European Commission indicated that it has concluded from its detailed assessment that the UK has an essentially equivalent, i.e. adequate, level of data protection to that provided for in EU law, which is required for an adequacy finding. This follows an in-depth consideration by the Commission of the UK's domestic law and international commitments, including, for example, in respect of the European Convention on Human Rights, and the mechanisms for oversight and redress in place for data subjects. However, whilst this is the first formal step in a process, which would mean that if successfully concluded, personal data could continue to flow freely from the EEA to the UK, assuming that other GDPR requirements continue to be complied with, it isn't the end of the story. So the draft adequacy decisions will next be scrutinised by the highly influential European Data Protection Board, which will produce a non-binding opinion. And we believe that that is likely to be expected around mid-April. And that must then be considered with the proposals, with the drafts from the Commission, by a panel of representatives from the EU member states. Now, the adoption of the implementing acts, the adequacy decisions in this case, the reason for this procedure, the reason for this process is because they're subject to what is colloquially known as the EU Comatology Procedure, which is used for the adoption of tertiary legislation. And under the EU GDPR, the examination procedure, which is part of comatology, is going to be used, and that requires greater in-depth examination and generally a vote by the EU member states. It is currently unclear how long this process, this comatology procedure, will take, and whether any changes or qualifications will be requested to the proposed approach in the adequacy decisions. The EU Commissioner for Justice, Didier Reynders, has suggested in speaking to the European Parliament that the adequacy decisions could be adopted, fingers crossed, as soon as the end of May or beginning of June. It is noteworthy, however, that there is a spirited debate underway in Brussels, not least in the European Parliament, in respect of the content of the current draft adequacy decisions and whether they should be adopted in their current form. Areas of controversy include processing in respect of surveillance, as was the case in the Court of Justice's judgment in Schrems 2. So just to sidestep briefly into Schrems 2, as I'm conscious that that is a key case and it's something that we're sure that IT practitioners have previously heard of. Schrems 2 was a ruling of the EU Court of Justice last year and has been retained also in UK law at the end of the Brexit transition period. In that case, the Court of Justice struck down the EU-US Privacy Shield, which acted as a partial adequacy decision, allowing for transfers between the EU and the US of personal data by certified organisations. And the reason that the Court of Justice did this, in very short summary form, is that it raised concerns. In its judgment, it set out concerns linked to the applicable national surveillance laws in the US, and that those laws infringed certain rights in the EU Charter of Fundamental Rights, including, for example, the right to an effective remedy. And so they couldn't be relied upon, that legal regime in terms of those national surveillance laws couldn't be relied upon in terms of the level of protection that it was offering to data subjects. So the court ruled that the Privacy Shield could no longer apply, that it was invalid thenceforth. But the court did also rule that it was possible for standard contractual clauses to continue to be used, and we're going to come on to this in a later slide. However, in terms of the use of standard contractual clauses, that needed to be subject to a detailed assessment of the law applicable in the third country and the potential for access by public authorities to the relevant data, together with the processing plans to be undertaken by the relevant entity in that jurisdiction. And an assessment needed to be made whether the data protection that would be applicable would be essentially equivalent to that of the EU. So, coming back to the draft EU adequacy decisions, if the GDPR, the EU GDPR adequacy decisions are not adopted in respect of the UK by the end of the bridge, businesses wishing to continue to transfer personal data from the EU to the UK will need to consider what alternative EU GDPR criterion for international transfers they will rely on. However, should the adequacy decision be approved by the end of the bridge, it will mean the continuation of frictionless data transfers between the EU and the UK, and clearly that would be a much more beneficial position in terms of businesses wishing to undertake such transfers. Now, the UK Information Commissioner welcomed the publication of the draft adequacy decisions, and I think from our perspective as solicitors practicing in this field, it's clear that it would be a relief for many businesses wishing to avoid further expenditure to guarantee ongoing transfers to the UK. But we'll see what happens next. And given the uncertainty on the timing and outcome of the EU adequacy decisions in respect of the UK and if and when those will be adopted, the Information Commissioner's Office still recommends that businesses put in place alternative safeguards for transfers from the EU or EEA to the UK before the end of April. Now, I'm going to hand over to Kat, who's briefly going to talk to you about international transfers from the UK, and then we will move on and back to EU standard contractual clauses and some of the developments there. Thanks very much, Kat.
Thanks, Joanna. So we've now covered transfers from the UK to the EEA and vice versa. But what happens to transfers from the UK to non-EEA third countries? Well, aside from making an initial finding that the EEA states offer an adequate level of data protection, UK ministers haven't yet made any additional adequacy decisions, and neither they nor the ICO have proposed any new standard contractual clauses. And in fact, they are precluded from progressing this work without the EU agreement during the bridge period. So how can such transfers continue? Well, a series of transitional provisions have been added to Schedule 21 of the UK Data Protection Act 2018, and these enable businesses to rely on existing EU adequacy decisions and standard contractual clauses as they apply at the end of the Brexit transition period for these transfers from the UK to third countries. In practice, this means that transfers, for example, from the UK to the US, subject to undertaking the due diligence required subject to the Schrems II judgment that Joanna mentioned earlier, businesses can continue to rely on the EU approved standard contractual clauses, although we do recommend that these are slightly adapted as is permitted under the UK Data Protection Act, for example, to refer to the UK instead of the EU, and to ensure that the correct legislation is referred to in the drafting of these. I'll hand back over to Joanna now.
Great, thanks very much, Kat. So one further element that we wanted to draw to your attention, which is relevant to some processing undertaken by IT practitioners and others, is in relation to the EU Withdrawal Agreements. Now, whilst the transition period under that agreement has been and gone, and we are at the end of the Brexit transition period, and the UK has no longer formally applies EU legislation as it is now being treated as a fully separate state. One further point to note is that some of you may be aware that the EU-UK Withdrawal Agreement did contain a section on separation, which was to set out what would happen to personal data within the scope of EU law processed in the UK prior to the end of the Brexit transition period, or on the basis of the withdrawal agreement itself. And this is known as legacy data. So this is relevant for businesses, as the relevant article, Article 71 of the Withdrawal Agreement, indicates that the EU GDPR, as it was at the end of the transition period, the UK Information Commissioner's Office even describes it as the frozen GDPR, and other EU data protection law still applies to the processing of such personal data of individuals outside of the UK. So whether they are in the European Economic Area or elsewhere, unless and until there is an EU adequacy decision in respect of the UK. So this is something to bear in mind, as it may be relevant in certain cases and also affect your assessment of which legislation is applicable to the processing that you're undertaking. So I'm now going to hand back to Kat, who is going to talk to us a bit about the developments in terms of EU standard contractual clauses and how those may also have relevance to the UK. Thanks very much, Kat.
Thanks, Joanna. So yeah, from a practical perspective, we also wanted to cover the recent developments concerning the EU standard contractual clauses. So as some of you might be aware, there has been speculation for some time that new standard contractual clauses would be adopted to reflect changes in EU legislation, such as the introduction of the EU GDPR and how the legislation has since been interpreted by the Court of Justice, for example, in the Schrems II decision. The limited nature of the currently approved clauses, so they only cover at the moment controller to controller and controller to processor transfers, has also caused some practical challenges in some scenarios. For example, there wasn't a provision for a scenario where there was a processor who wished to transfer data to a sub-processor that was located outside of the EEA, for example. So as you may know, in November of 2020, the European Commission published their new draft standard contractual clauses, which would replace the existing standard contractual clauses and also be subject to the comatology procedure that we mentioned earlier in relation to their adoption. Under the GDPR, standard contractual clauses, together with any supplementary measures that may be required following Schrems II to ensure an adequate level of data protection, are a form of appropriate safeguards. And as we've mentioned, these are one of the criteria that businesses can rely upon under the GDPR transfer personal data to a third country that doesn't currently benefit from an adequacy decision from the European Commission. The proposed EU standard contractual clauses have been broadly welcomed, as the current versions still contain references to previous data protection law and are viewed as increasingly out of date as the complex nature of international data flows has evolved. However, there have been detailed debates about the content of these drafts, included by legal practitioners and bodies representing regulators and so on. So the revised draft standard contractual clauses now cover 4 different potential data transfer scenarios. So as mentioned, the previously covered controller to controller and controller to processor scenario. The new drafts now also contain provisions relating to processor to processor and processor to controller transfers. I'll hand over to Joanna now to talk a bit more about these drafts.
Great, thanks very much, Kat. So just to kind of step back, where are we now? Well, the Commission published the draft EU standard contractual clauses in autumn last year, and it ran a public consultation on those new draft clauses, which ended in December. And many of the responses to that consultation can be viewed online on the European Commission website. So what we've done is we've drawn out in the next section for you a few of the key changes that are proposed and some of the key points to be aware of from the perspective of IT practice, but also we've just tried to flag where we're aware that there are particular areas of debate as to whether this is the best drafting approach, and it's possible that we may see changes in the final EU standard contractual clauses which are adopted. So just in terms of key changes, well, the first will be a change in approach, with the current EU standard contractual clauses ceasing to be available for use for transfers from the EEA for new contracts which are changed, or existing contracts, though for those latter existing contracts, the proposals build in a 1-year grace period in order for standard contractual clauses to be updated. Now, in the 1-year grace period, existing standard contractual clauses in use for contractual arrangements in the context of the EU GDPR are intended to be updated by the new clauses, though it remains to be seen if ultimately that will be the approach adopted. So, for example, the Law Society of England and Wales and the City of London Law Society have suggested that it would be easier in practical terms for businesses if, instead of the new EU standard contractual clauses being required to be used for existing contracts, such clauses would be entered into for new contracts, but clauses, the current EU standard contractual clauses entered into before the beginning of the grace period could continue to be recognised in order to reduce the burden of time and cost for businesses to replace such clauses. And so you could see an argument, for example, that such clauses are currently being used with other steps in order to ensure compliance with Schrems II and the EU GDPR. But we'll have to see how consideration on that point progresses in Brussels. Another option might be to provide for a longer grace period than 1 year, or perhaps for it to be widened. So what do we mean by widened? Well, in this regard, a further point is that the US Software and Information Industry Association has provided a response to the consultation, and it pointed out that in the case of its members, many of them, and we're conscious it would be the same for IT practitioners in the UK and in other parts of Europe, may contract on a daily basis. Now, under the current proposals, such practitioners would be required to switch to the use of the new clauses for any new contracts or any changes to contracts as soon as they take effect. And that leaves very little time for effective implementation or adaptation. So perhaps instead the grace period could be applied more widely to allow for a period of implementation and bedding in. Now, we'll have to see what happens in terms of that debate. Another element which is quite interesting in the standard contractual clauses themselves is that they take further trying to reflect in the drafting the requirements that the Court of Justice set out in its judgment in Schrems II. And of course, those are an interpretation of the EU GDPR. So these are EU GDPR requirements. Now, perhaps one of the most challenging aspects of the new clauses is in terms of the significant requirements for the use of those appropriate safeguards, the standard contractual clauses. And the current draft proposes to require that the parties warrant that they have no reason to believe that the laws in the third country of destination applicable to the processing of the personal data by the data importer, including any requirements to disclose personal data or measures authorising access by public authorities, prevent the data importer from fulfilling its obligations under those standard contractual clauses. So this is linked to the due diligence requirements imposed by Schrems II and the need to ensure this essentially equivalent level of data protection with EU standards. And I think that the interesting point is whether and how this would be workable in practice. So, for example, would this be a very onerous thing for businesses to be able to warrant, including SMEs, in terms of the assessments that they would need to make, and how would they do that in practice? But of course, these are requirements that are set out in the Schrems II judgment, and so are required to be complied with. The other point that data importers would be required to take steps in respect of is that they would be required to give a warranty in relation to making best efforts. So an important level of efforts to provide the data exporter with relevant information in the assessment of the third country's laws, so where the importer is based, the laws applicable to them, and must promptly notify the data exporter if circumstances change, which mean that the data importer cannot fulfill its obligations. So this in effect is an ongoing monitoring requirement, and may be harder in principle for smaller to medium-sized businesses to meet without expending additional resource. That said, it again is already a requirement within the context of the Schrems II judgment. So I think seeing how this plays out in practice and any guidance that is issued alongside the standard contractual clauses will be really interesting. Now, from a more technical perspective, a couple of points which we thought would be particularly of interest to the IT profession. So the draft clauses also include a docking clause, which is designed to allow third parties to subsequently accede to the standard contractual clauses if the parties involved in the data processing arrangements are subject to change. So this looks potentially very helpful and more flexible than the arrangements we have available at the moment, as it should reduce the number of separate contracts that businesses might need to enter into. However, there is still some uncertainty in terms of the mechanics on how this would work or be agreed in practice. And we are hopeful that there can be some further clarity when the final version of the clauses is adopted. Another point to note is in terms of the notification of breaches in terms of the processing of personal data. So the draft clauses provide for an obligation on non-EEA controllers in importers, so in a third non-EEA state, to notify not only data exporters, but also the relevant EEA supervisory authorities concerning personal data breaches. Now, again, there are some questions about how this would operate in practice and whether another approach might be more appropriate, particularly given that it may be that in some cases such non-EEA controllers are not always bound by the EU GDPR directly. Now, the other side of it, of course, is that there needs to be an effective means of reporting and notifying breaches. And so I think we'll see where that debate ends up in Brussels, but it's another area where there may need to be some further clarity. The other point that we thought might be interesting is in terms of a provision in the standard contractual clauses that have been proposed, that any sub-processor can be audited by the controller. So while understandable from the perspective of the EU GDPR requirements, in which the controller determines the means and purposes of the processing and has ultimate responsibility for such processing and providing instructions to processors, etc. Depending on the arrangement, this may not always prove practical, particularly if there isn't a direct relationship between the controller and the sub-processor. So again, we need to see if there are any changes or clarifications to this requirement, and we're conscious this could be particularly relevant in an IT context. I think just finally to note, there is also some uncertainty in terms of the liability provisions in the drafting, and we'll see if further clarity is available in respect of those. And for example, if you have drafting indicating uncapped liability in terms of the standard contractual clauses, what would that do if you had a broader liability clause elsewhere in a commercial arrangement? And this is another point that the Law Society of England and Wales and the City of London Law Society have queried in their consultation response. So I am now going to hand back to Kat, who is going to provide a little bit more of an update on where we stand in terms of the process on these EU standard contractual clauses. Thanks very much, Kat.
Thanks, Joanna. So further to the consultation, the European Data Protection Board also produced a joint opinion with the European Data Protection Supervisor in response to the draft clauses. And they made several suggestions, for example, stating that they would like to see the Article 28 GDPR requirements, so those are the provisions covering data processing agreements, as well as in respect of appointment of further processors. They want the Article 28 provisions more clearly incorporated into the drafts of the standard contractual clauses. And they also made several other suggestions. Now, the final EU standard contractual clauses are expected to be adopted early this year, and it was originally thought that they might come even this month. However, it does remain to be seen whether and to what extent any changes stemming from the commentary so far and from the consultation will be incorporated into the final versions of the standard contractual clauses. Another point that is very important to note is that the new EU standard contractual clauses will not directly and automatically apply in UK law following Brexit, as the UK has retained the currently applicable EU standard contractual clauses in UK law. Under the Data Protection Act 2018, the ICO and Secretary of State have the power to propose new UK standard contractual clauses in relation to international transfers of data. and this is expected to take place following the end of the bridge period, with the ICO suggesting that the consultation and the implementation of these will happen during 2021. However, of course, it does remain to be seen how substantially these new UK standard contractual clauses will differ from the European Commission's current proposals. So I'm now going to hand back over to Joanna to talk about the EU-US Privacy Shield.
Great. Thanks very much, Kat. So hopefully the slide should change shortly. So the final area that we wanted to touch on is the developments in terms of EU-US data transfers. So you will remember, as we've already mentioned, and I'm sure you're separately aware, that the Court of Justice invalidated the EU-US Privacy Shield last July. And that was after also previously invalidating the prior safe harbour decision. And there has been much debate as to whether there could in future be a further successor agreement put in place and on what other options are available. So why is this important? Well, it's important to ease transatlantic data flows and to ensure that there are means by which those can continue for businesses. And while the Schrems II judgment held that the EU standard contractual clauses remain valid, it indicated that they can only be relied upon in cases in which an essentially equivalent level of data protection is maintained, and that supplementary measures may be needed to achieve that. Now, consideration is still continuing in terms of what that means in practice, what are supplementary measures. And the European Data Protection Board has published some recommendations themselves that have been subject to a consultation, indicating perhaps what supplementary measures there could be and how those should be applied. But it has also noted that in some cases, no supplementary measures would be available to enable transfers to be undertaken. So, for example, such measures could include pseudonymization, encryption, where the key for decryption is held in the EEA, and cannot be, and the data cannot be decrypted in the relevant third country, or possibly splitting the data out between different jurisdictions so that it cannot be essentially put back together in a way that the personal data could then be accessible from those separate jurisdictions. But what this means is that in cases in which actually what you would need to do is to be able to send unencrypted or unpseudonymized personal data for processing in a third country, in which actually without supplementary measures you cannot meet the Schrems II requirements, is that there's no way at the moment for that to be EU Gdpr compliance, fully compliant. So there is a need. There is a need to see what further steps can be taken to see if there is a possibility of, for example, in the case of EU-US data flows, another solution. And that's why there is this search for a broader solution. So the Court of Justice's analysis in Schrems II was broad-ranging, but the judgment particularly focused on certain US laws, including Section 702 of the Foreign Intelligence Surveillance Act and Executive Order 12,333. And those relate to the surveillance of non-US persons. And in the court's view, essentially elements of those laws and their application was disproportionate in terms of whether sufficient rights were actually provided to the data subjects concerned. So what's happening now and what progress might we see going forward? Well, we understand that last week the US Secretary of Commerce and the EU Commissioner for Justice met to discuss transatlantic data flows, though no further details are available. However, also very recently on the 17th of March, the Congressional Research Service in the US published a new report setting out a number of potential options that US lawmakers could consider in terms of improving transatlantic data flows and making those easier for practitioners. And so they focused on three broad headings in terms of possible options. One of those is executive action. And so the example provided was if, for example, the US president issued an executive order to limit bulk data collection in certain scenarios. Diplomacy, and the obvious example there is for a potential replacement of the Privacy Shield with a further successor. And legislation, so this could, for example, be amending some of these surveillance laws in the US. Now, in terms of next steps, it's not clear on the exact approach. It's not clear on exactly how this will progress, though it's likely to take some time for developments to be seen. But it's clear that there is will in order to find if there are ways forward in respect of this. So I think one of the challenges, as outlined by the Congressional Research Service, is that perhaps EU and US laws start from a slightly different place, in that under EU law, the protection of personal data is viewed as a fundamental right. It's contained in the EU Charter. And of course, what we need to see is a way that standards of data protection under EU law can be maintained and carried with data as it moves to third countries. But it's certainly possible that a solution could be found here. And so we're certainly interested to see what impact any such developments that could be brought forward to resolve this issue would have in respect of firstly EU to US data flows, but also if those could then have a corresponding influence perhaps on US to UK data flows in future as well. So prior to the Schrems II ruling, in a previous research paper, the Congressional Research Service had, among others, suggested that the US and the UK might agree a privacy shield that would have been similar to the EU-US privacy shield that was in place at that time. And clearly that's no longer possible given that the privacy shield has been invalidated. But perhaps if a solution could be found for EU to US data flows, something similar might be possible to adopt in respect of UK to US data flows. So we certainly are crossing our fingers, and it would be very helpful, I think, if there was a solution available. But in the meantime, I shall hand back to Kat just to wrap up, and then we can move on to any questions. Thank you.
Thanks, Joanna. So just to conclude, I think we've demonstrated that the recent developments in data protection law have caused seismic shifts in the UK and EU data privacy landscape, and have unfortunately caused greater uncertainty for businesses. I think one of the key takeaways is that in determining the extent of your obligations and how best to undertake international transfers to and from the UK and the EU, businesses should be careful to consider each data protection regime independently, particularly given their extraterritorial effect, and keep an eye on other developments which are anticipated soon that we've mentioned previously. So that's all from us. Thank you very much for listening, and we'll be happy to take any questions that you have.
Great. Thank you very much, Kat. So,
thank you very much, Joanna and Catherine. So far, there haven't been any questions raised in the chat or the questions section. Now there is one. So it's from Daniel Hulsman. I can read it, but then if Daniel, you wish to take the floor, I will unmute you. So it is not true that the adequacy decision is subject to regular review and that this may be repealed. For example, the EEA may view with great concern the UK government's intention to increase its mass Is there anything that businesses should be doing to prepare or protect themselves? So that's the question, and I will just quickly see if there is a raised hand from Daniel, if he wishes to complement, to say something more. If not, then if you, Joanna or Catherine, if you could please take the question.
Yeah, that's fine. And Panagiotis, so I've turned off the slides, so I don't know if there's a way that that we can put the video on, or if Daniel and the other attendees can see us already. Otherwise, I can put the slides back on. But I will just respond. So in terms of the draft adequacy decisions, Daniel, you're absolutely right that at the moment the approach that the Commission has taken in the draft proposals it has made is that they can be open to review every 4 years as adequacy decisions. But of course, on top of that, there would be a continuing review. And we know from experience of the Schrems II case and the invalidation of the EU-US Privacy Shield that in terms of the application of adequacy decisions, they can be struck down, and legal challenges in this area are clearly potentially quite prevalent in the future. So certainly in terms of businesses, I think the key is to be very aware of your data processing activities, the transfers that you would wish to make, and essentially to have a plan and to know what you would do if an adequacy decision wasn't in place. So for example, one of the key options available to you is to rely on standard contractual clauses, and in terms of meeting the requirements for those, it's also going to be about being prepared to undertake a due diligence exercise to ensure that the country that you're transferring the personal data to and the importer in that country are able to guarantee that essentially equivalent level of data protection.
Thank you, Joanna. In essence, Daniel had his hand raised, so I will unmute him in case he wishes to complement the question, although there has been a very good answer. So Daniel, if you wish to complement your question, please, I will unmute you and you could speak. So I unmute you now. Please complement your question if you wish to say something more. You have to also unmute it on your side.
Not so much of to complement the question. Just wanted to thank you for answering, and apologies for missing off a word. It was about mass surveillance, but your answer was perfect. Thank you very much.
No problem.
Thanks, Daniel. Then there is a next question from Olivia Boss. There is also another question, not the one I've just mentioned. Was a great presentation, needs further time to absorb, but in effect, are we all still to await how discussions and new regulations emerge? So this was another question from a speaker that wishes to remain anonymous. So this is, I will not give the floor, but if you could take the question. Thank you.
Yes, of course, that's fine. And I think that I'm afraid is absolutely the case at the moment. So there are many different elements that are in flight at the moment. So we need to see if there are going to be EU adequacy decisions approved in respect of transfers to the UK. We need to see what EU standard contractual clauses are approved. We need to see if the UK follows the approach in those EU standard contractual clauses, and we need to see if, fingers crossed, there is a solution, a better solution available in terms of transatlantic data flows eventually, and to any other third countries as well, if if in future those become areas where it's very important to guarantee those data flows. So I think there is a lot in train at the moment. It's really important to stay aware of the developments, but I think the key is knowing what your own processing activities are, and being aware of potentially in the future if an adequacy decision wasn't available for a particular data flow, what would you do instead, and just to have a plan for that. And I think that's the best way to be prepared in the future.
Thank you. There is another question. There are some questions and some raised hands. I will take it in sequence. One question from Duncan Mackenzie. How long would it take to bring a UK-US privacy shield into being, into existence? This is the question.
So that's really interesting, because I think it would depend. I think there's one element to that, which is that in terms of the procedure, in terms of adopting an adequacy decision under the UK Data Protection Act 2018, it's a slightly different procedure now. They're actually going to be known as Adequacy Regulations, and of course the Privacy Shield was essentially a qualified adequacy decision. So it would be subject to the Adequacy Regulations provisions, and essentially what that would mean is that you would have an assessment made, that the Secretary of State would make a recommendation, and ultimately that would be scrutinised within the UK. So, for example, scrutinised by Parliament. But that could all be done technically very quickly in relative terms. I think the key is about the level of data protection in the US, and whether or not that can be viewed as giving the relevant level of data protection, given that we have retained the Schrems II judgment in UK law. So potentially, in a positive scenario, if those requirements had, for example, been met for an EU-US privacy shield replacement, then we have a very similar data protection regime in the UK. So it might be possible quite quickly. Equally, it might take longer.
Thank you very much, Joanna. There are no further questions in the questions panel, and I see also nothing in the chat. So I would like, before closure, to ask everybody who would be willing to raise the final question just to raise their hands. I cannot see any raised hands, so I would like to thank very much Joanna and Catherine for this great presentation. I would like to thank all of you also for being here. The next event will be in April, mid-April, 15th of April as a date. So we look forward to seeing all of you there virtually. And I would like just to pass the last sentence to Joanna and Catherine for the closure. And thanks once more very much for being with us.
So thank you everyone for joining. It's obviously a very interesting but also quite uncertain area in terms of data protection at the moment. So we hope this was helpful. We certainly find it very interesting. So if you do have any other questions, feel free to get in touch. Some aspects of this may take longer than others to resolve, but I think we will see progress, and hopefully in a positive direction for IT practitioners.
Thank you very much. There are already thanking notes in the question panel and the chat. So thank you very much for being with us, and we'll see you soon. Goodbye.
Thank you.
Thank you.
Thank you.